I reviewed asylum files where the client survived torture, fled across 3 countries, and arrived in the US with testimony no judge could reasonably doubt. Some of those cases still got denied anyway. The story held, the file didn't. In this video, we'll discuss the 5 evidence categories every immigration judge or USCIS officer weigh your case against, and how to build a record that holds up when the documents you'd want simply do not exist. One piece of asylum law is worth establishing first. Credible, persuasive testimony can sustain an asylum claim on its own. That's codified in the 2005 corroboration framework, and the BIA has applied it consistently since. A truthful applicant with testimony that hangs together can win without a single corroborating document. But the same framework tells the immigration judge to consider whether reasonably available corroboration was provided. That phrase is the entire ballgame. The IJ is asking a narrower question. What should this person realistically have been able to produce, and does the file show they tried? A file that explains its gaps is defensible. Silence around the gaps becomes the reason for denial. Strong asylum cases don't need a thick file. They need a defensible one. Quick context. My name is Julio Costa, and I've spent the last 6 years drafting and reviewing asylum cases before the immigration courts, BIA, and USCIS. This is educational content, not legal advice. Every case is different. So if you're handling a real case, talk to a qualified attorney. The first category is what I call the naked claim, a declaration that tells the story with almost nothing behind it backing it up. The strongest package has witness affidavits, photos of injuries, preserved threat messages, medical records, school or church records that anchor the timeline. Reality rarely delivers all of that. Witnesses fear retaliation, phones get lost during flight, documents get left behind, family won't mail records because the persecutor watches them. The work is to defend the absences. For each missing piece, show why it's missing, where it would be, and who could have provided it. Here's how this gets argued badly in the pretrial brief. Respondent has provided credible testimony regarding the persecution. The record supports her claim. And here's how it gets argued well. Respondent's testimony regarding the July 8, 2019 attack outside her church in Hargeisa is detailed and consistent. Reverend Adisa, who witnessed the attack, has been in hiding since late 2019 and could not be located despite documented attempts by respondent's uncle Yusuf in 2021. See Yusuf Declaration at Exhibit 7. Country conditions at Exhibit 14 established the surveillance of opposition families in this region, providing context for why a sworn witness statement could not safely be obtained. Notice that in this version, we named the witnesses, we documented attempts, the reason for failure, and country condition sites. The IJ or USCIS officer have something to weigh. Apply the diagnostic. Why doesn't the witness statement exist? In this case, the witness is in hiding, and that's in the record. Gap defended. Name what's missing, or the silence becomes the story. The second category is the country conditions dump. A file with substantial country conditions material that somehow proves nothing. The discipline isn't about size. Country conditions packages can be large and still be excellent. The discipline is about relevance, sourcing, and recency. Country conditions to speak to these client's persecutor, this client's region, this client's profile. They need to come from sources beyond the State Department, like the UN, HCR, Human Rights Watch, Amnesty International, regional NGOs, credible local reporting, or expert affidavits where the issue requires one. Here's a common theme though. Applicants file a generic country conditions package, mostly made out of State Department's material, describing the country in broad strokes. The brief never connects any specific source to any specific allegation. The IJ has to do that work herself, and most won't. Here's how this looks argued badly. Country conditions establish that gang violence is widespread in Honduras and that the government has failed to address it. And here's how it looks argued well. Respondent was a public school teacher in Olancho who refused to permit MS-13 recruitment in her classroom. The country conditions record corroborates her specific risk. A 2024 Inside Crime report at Exhibit 14 documents MS-13's targeted recruitment of rural Olancho schools. A 2023 Human Rights Watch report at Exhibit 15 establishes the gang's pattern of using family members as leverage when targets flee. Both sources track the specific persecutorial pattern respondent describes. That's why you should curate, or you've handed the judge a research project. The third category is the targeting void. The file shows that something bad happened, but doesn't show that the harm was directed at this client on account of a protected ground. Asylum requires a nexus between the harm and a protected characteristics such as race, religion, nationality, political opinion, or particular social group. Random violence and personal disputes do not qualify. The case has to show the persecutor came for this applicant because of who they are. Here's what proves directed targeting. Police reports naming the applicant, even refused ones, because the refusal itself becomes evidence. Restraining orders, threatening letters, voicemails, dated text messages sent to this person, photos of the aftermath of an incident, named persecutors with identified affiliations, witness statements that can describe the targeting and the protected ground motive. Come in reality. The persecutor was unnamed, masked attackers, anonymous calls, in an identified mob. The harm happened, but nothing in the file ties it to this applicant by name or shows why this applicant was singled out. Here's the weak pretrial brief. Respondent was attacked multiple times by individuals who appear to be politically motivated. Here's the pretrial brief that does the work. Respondent was attacked on 3 occasions in 2019. March 2nd, June 14th, and August 30th. The attackers wore the La Piedrita Colectivo armband each time. See photographic evidence at Exhibit 9. Respondent recognized 2 of them. Marco Villanueva, a former neighbor, and a man known as El Chato, both identified by witnesses as Colectivo enforcers. See Exhibits 10 and 11. The targeting was on account of respondents' documented opposition to the ruling party. See Exhibit 12. Now we have dates, named actors, photographic corroboration, witness identification, in an explicit protected ground nexus. The targeting has fingerprints. Real targeting leaves traces. Find them or account for them. The fourth category is the assertion problem, the most fixable category in the framework, and often the most frustrating to see fail. The strongest evidence of government failure is documentary. News articles on systemic impunity in the client's region, an expert affidavit from a country specialist or a human rights researcher, NGO reports on state failure to protect the client's group, prior failed attempts by the client or family. In practice, applicants make mistakes in drafting a declaration that says only, "The police don't help people like us," and that's it. The IJ has no way to distinguish real systemic failure from a one-off frustrated client. Country conditions evidence may exist in the file, but never gets tied to the specific assertion. Here's what a weak pretrial brief looks like. The Eritrean police are unwilling to protect citizens who oppose the government. Here's a pretrial brief that proves it. Documentary evidence establishes that the Eritrean state's failure is systemic, not anecdotal. Country conditions at Exhibit 14 show the Asmara Central Police are operationally controlled by the ruling People's Front for Democracy and Justice. Dr. Jonas Baraki, an Eritrean human rights researcher, has submitted a declaration at Exhibit 15 which demonstrates that complaints against PFDJ-affiliated actors are routinely refused, and complainants are often detained themselves. Respondent's own family confirms the pattern. When they attempted to report her brother's 2018 disappearance, her father was detained for 4 days afterward. See Exhibit 16, Detention Records. Notice how the second brief brings together country conditions, names of experts, institutional finding, corroborated incident, and documentary backup. Now the IJ has what she needs to rule. Don't tell the judge the police don't help. Show it on the page. The fifth category is the stale record, a file that proves what happened in the past and never quite catches up to the present. The strongest evidence of present tense risk is recent, dated, and specific. A message from family confirming the persecutor still asks about the client. Country conditions material establishing the persecutor still has reach. Incidents involving similarly situated people in the last 12 months. For clients who left years ago, documented attempts to verify ongoing risk, even when the verification didn't produce a clean answer. Here's what a weak brief sounds like. Respondent remains in danger if returned to Cameroon. Here's the pre-trial brief that holds up. Recent corroborated evidence establishes present tense risk. In February 2026, respondent's sister Adele reported that 2 Ambazonia Defense Forces members visited the family compound in Guea and asked specifically when respondent would return. See Exhibit 17. The Crisis Group's March 2026 report at Exhibit 18 documents that the ADF still controls the Buea-Limbe corridor and continues targeting returnees. Respondent attempted to verify additional incidents through 3 classmates in country. 2 did not respond, 1 declined citing surveillance. Exhibit 19 documents the surveillance practices that explain those failures. On the page now, dated communication, named family member, named faction, current country conditions sourcing, account of failed verification attempts. Past persecution gets the case heard. Document the present or the case stays in 2018. Here's how immigration judges actually write about evidence gaps in their decisions. The first one is a denial. The IJ is articulating exactly the problem we've been talking about. Respondent testified that her former employer in her home country maintained personal records that would have corroborated the harassment described. The record contains no explanation for why those records were not produced or attempted to be obtained. Without such an explanation, the court cannot credit the corroborative weight those records would have carried, in the absence of any reasonable accounting weighs against respondent's claim. Read what the IJ wrote carefully. She points to the records, then to the silence around them. The silence is what she penalizes. The gap was defensible, but nobody defended it. Here's an acceptance on the same kind of gap. While respondent did not produce a police report regarding the November 2019 incident, the record reflects credible testimony corroborated by an expert affidavit on conditions in the home region, that local police were aligned with the persecutors, and that any attempt to file a report would have placed respondent at greater risk. The court finds the absence of a police report adequately explained and does not weigh against credibility. Same kind of missing document, same kind of credible client, different outcome because the record explained the absence. The IJ has what she needs to find for the applicant. The same gap can sink a case or save it. The record decides which. Remember, corroborate what you can. Curate country conditions to this claim. Document the personal targeting. Prove government failure. Don't just assert it. Show the risk is present tense. For every gap, explain why on the record. 6 moves, run them on every case. Skip the thick file. Build the defensible one. If this was useful and you haven't seen my video on asylum declarations, the 5 red flags that sink credible cases before they ever reach a hearing, that one pairs directly with this. Link is in the description. Like and subscribe if you want more breakdowns like this. And if there's a specific topic you want me to cover next, like a procedural move, a doctrinal question, something you keep seeing go wrong in real cases, drop it in the comments. I read them, and the topics I cover come from what people actually are asking. Thanks for watching, and as always, keep your steps steady and your purpose clear.